Thank you, Madam Chair. All the members of the panel agree that voting discrimination still exists, and we do disagree on how to address the problem. And the Supreme Court invited Congress to address the problem by updating the coverage formula. And the Supreme Court, I note, maintained the principle of pre-clearance. They did not strike that down. They struck down the coverage formula and invited Congress to change the coverage formula, which is what this bill does. And to say that the formula in this bill is unconstitutional, I would say is definitely premature. We do have members of the House of Representatives who are here, and I note that the companion bill in the House is supported in a bipartisan way. And I am hopeful that as we proceed with this discussion on this bill, that we'll be able to come up with a compromise version or a bill that will do what we need to do to maintain our Voting Rights Act and get bipartisan support in that regard. And I also want to note, and thank you, Ms. Eiffel, for being very clear that this bill does not punish states for historic discrimination in any kind of, we're going to designate a particular state for this treatment because no county or state is singled out. And in fact, the requirement that is in this bill that requires 5 violations or 3 violations of Section 2, that seems to me a pretty high standard before the pre-clearance requirements kick in. Would you agree with that, Ms. Eiffel?
Indeed, I would. I would think that a jurisdiction that is able to meet that number actually is on the high side in terms of egregious conduct. I think actually this Congress has been quite conservative in trying to create a formula that frankly leaves quite a bit of leeway there for states and for local jurisdictions. In fact, one of those 5 for a state has to be a statewide violation. So there are lots of ways in which I think the drafters of this bill have tried to be as deferential to Congress as possible. But I would also point out again that with regard to the sovereignty of the states, it is the Constitution of the United States in the 14th and 15th Amendment that gives this Congress the authority and the obligation to protect against voting discrimination. And those 2 amendments are specifically targeted at the states. They are telling this Congress what to do to protect and frankly, historically, to protect against voting discrimination that happens in the states.
Well, I note in your testimony, Ms. Eiffel, that Section 5 blocked dozens of discriminatory voting changes over the decades that this law has been in place. And can you just describe to us what some of these discriminatory voting changes were that were struck down under Section 5, and whether, in fact, post-Shelby, the same kinds of voting changes are being put in place throughout our country in many states?
Well, you've heard some of them this morning, Senator. You've heard about polling place changes. You've heard about shifting elections and reducing the seats, the districts in particular elections. You've heard about redistricting, of course, taking populations and annexing populations from adjoining jurisdictions to try and create majority white districts.
Are these, excuse me, are these the same kinds of restrictions that were struck down pre-Shelby?
I think that's what we find most disappointing, Senator, that a lot of what we're seeing is precisely the kinds of electoral changes that Section 5 protected against and that the Voting Rights Act was meant to protect against. We're seeing jurisdictions return to the same kinds of tactics that were used in the past to hold on to, as Mr. Johnson says, power, political power.
Reverend Johnson, we've heard testimony that this current Attorney General is particularly diligent in enforcing the Voting Rights Act. Now, in the decades that this law has been in place, hasn't Section 5 been used by both Democratic and Republican Attorney Generals to enforce the Voting Rights Act?
Absolutely. In 2006, the congressional record overwhelmingly demonstrated the need for continued federal protections, 750 Section 5 objections by the Justice Department over that time period of this law being in effect, 800 potentially discriminatory voting changes, 105 successful actions to require covered jurisdictions to require with Section 5, 25 denials of Section 5 preclearance by federal courts, high degrees of racial polarization in these jurisdictions, all mandated that the Attorney General of whatever party, of whatever president was elected to enforce this law.
Thank you. My time is up.